What up, y'all? It's your boy Jay Steves back with another 30 minutes of truth. Now, it might be a little bit over 30 minutes. Sometimes it might be less, but 30-ish minutes, okay? Today, we're going to talk about mortgages. I've said this to many people. I've told people this. People think that I'm crazy, which seems to be a theme in my life. But all mortgages. So if you have a house, you're buying a house. All mortgages are fraud. They're fraudulent. Why? Well, what most people don't know is that when you go to purchase a home, okay, and you have your promissory note, well, that promissory note is a negotiable instrument, okay, like a check or a cashier's check or something like that, right? It's a negotiable instrument. Now, what gives that paper value, right? Like when you take a check and you go write a check to someone, what gives it value? Is it you writing how much is on there? Is it you writing who it's to? No. What gives it value is your signature. Period. That's what gives it value. Now, what they do is they'll take the check, they'll deposit that check, and then they'll go and have your institution give them the money. So it's all double dipping, okay? It's all fraud. But with your mortgages, okay, your promissory note, when you sign that promissory note, they say, bloop, thank you. They take that promissory note that now has your signature on it. And on that promissory note, it says, I promise to pay blah, 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 right? So they take that, they deposit it for value into their institution, okay? Then they take that value and purchase the home. So then they purchase the home, and then you have your closing, right? So at your closing, now the house is purchased. They've created a trust in your name, okay? So that's why you have to sign the deed of trust. And with that deed of trust, you are the trustor, and the bank becomes the trustee, okay? So now they are the controlling entity over the property, right? But then on top of that, you also sign a deed of reconveyance. Now, before you sign that deed of reconveyance, okay, that house is yours. So when you sit down to close on your home, and before you sign anything, that house is yours. But then you sign the deed of reconveyance, okay? And now you just sign the rights for that property back over to the bank. So now you have to pay the bank back for the money that they took from the value of your signature and deposited in their institution. And you just signed over the house that was yours briefly, just sign it back over to them. And so now you got to pay them back. They didn't take any money out of their funds, out of their stores, right? So did they tell you that they were doing that? No, they didn't tell you that. Did they let you know that when you sign that deed of trust and it says, for the loan that I received, I will blah, 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 blah. Did you receive a loan? Did they give you cash or money? No, they didn't give you anything. Okay? So they purposefully aren't telling you anything about these papers you're signing. They're just telling you, sign here, sign this, sign that, sign this. And of course, just like the rest of America, we don't read anything. We don't read anything, and everything is in legalese, and we don't half understand it anyway. But I guarantee you that after you watch these videos, you're going to start reading your contracts. Everything I've shared with y'all is just going to make you angry. You're going to not believe me. Then you're going to see it. Then you're going to go and look at your deeds. You're going to look at your contracts. Or you're going to look at your birth certificate when we get to that point. And then you're going to be like, man, this is true. What is this world? What is this place we live? It's infuriating. It's infuriating. Well, just here to spread the news. Enjoy.
Episode 2.
Mortgage fraud exposed.
This is a promissory note.
Is there an agreement between Mr. Smith, the borrower, and the defendant?
Yes.
Do you believe the agreement includes a lender and a borrower?
Yes. I'm the lender and Mr. Smith is the borrower.
What do you believe the agreement is?
We have the borrower sign the note and we give the borrower a check.
Does this agreement show the words borrower, lender, loan, interest, credit, or money within the agreement?
Sure it does.
According to your knowledge, who was to loan what to whom according to the written agreement?
The lender loaned the borrower a $200,000 check. The borrower got the money and the house and has not repaid the money.
Do you believe an ordinary person can use ordinary terms and understand this written agreement?
Yes.
Okay. Do you believe you or your company legally own the promissory note and have the right to enforce payment from the borrower?
Absolutely we own it and legally have the right to collect the money.
Does the $200,000 note have actual cash value of $200,000? Actual cash value means the promissory note can be sold for $200,000 cash in the ordinary course of business.
Yes.
So, according to your understanding of the alleged agreement, how much actual cash value must the bank loan to the borrower in order for the bank to legally fulfill the agreement and legally own the promissory note?
$200,000.
Okay, so according to your belief, if the borrower signs the promissory note and the bank refuses to loan the borrower $200,000 actual cash value, would the bank or the borrower own the promissory note?
Well, the borrower would own it if the bank did not loan the money. The bank gave the borrower a check, and that is how the borrower financed the purchase of the house.
Okay. Do you believe that the borrower agreed to provide the bank with $200,000 of actual cash value, which was then used to fund the $200,000 bank loan check back to the same borrower, and then agreed to pay the bank back $200,000 plus interest?
No, if the borrower provided the $200,000 to fund the check, there was no money loaned by the bank, so the bank could not charge interest on money it never loaned.
Okay. So if this happened, in your opinion, would the bank legally own the promissory note and be able to force Mr. Smith to pay the bank interest and principal payments?
Well, I'm not a lawyer, so I cannot answer legal questions.
Well then, is it bank policy that when a borrower receives a $200,000 bank loan, the bank receives $200,000 actual cash value from the borrower, that this gives value to a $200,000 bank loan check, and this check is returned to the borrower as a bank loan which the borrower must repay?
Well, I do not know the bookkeeping entries.
I'm asking you if this is the policy.
Well, I do not recall.
Okay. Mr. Banker, do you believe the agreement between Mr. Smith and the bank is that Mr. Smith provides the bank with an actual cash value of $200,000, which is used to fund a $200,000 bank loan check back to himself, which he is then required to repay plus interest back to the same bank?
I am not a lawyer.
Did you not say earlier that an ordinary person can use ordinary terms and understand this written agreement?
Yes.
Okay, Mr. Banker, I'm going to hand you back the bank loan agreement. This is Exhibit B. Is there anything in this agreement showing the borrower had knowledge or showing where the borrower gave the bank authorization or permission for the bank to receive $200,000 actual cash value from him in the note and to use this to fund the $200,000 bank loan check, which obligates him to give the bank back $200,000 plus interest?
No, there is not.
Okay, so if the borrower provided the bank with actual cash value of $200,000 in the note, which the bank used to fund the $200,000 check and returned the check back to the alleged borrower as a bank loan check, in your opinion, did the bank loan $200,000 to the borrower?
In that case, no.
So if a bank customer provides actual cash value of $200,000 to the bank, and the bank returns $200,000 actual cash value back to the same customer, is this a swap or exchange of $200,000 for $200,000?
Yes.
Okay, so did the agreement call for an exchange or swap of $200,000 to be swapped out for another $200,000, or did it call for a $200,000 loan?
A $200,000 loan.
Good. So is the bank to follow the Federal Reserve Bank policies and procedures when banks grant loans?
Yes.
So what are the standard bank bookkeeping entries for granting loans according to the Federal Reserve Bank policies and procedures? And I'll hand you now the Banker Fed publication entitled Modern Money Mechanics, labeled Exhibit C.
The promissory note is recorded as a bank asset, and a new matching deposit or liability is created. Then we issue a check from the new deposit back to the borrower.
So then, is this not a swap or exchange of $200,000 for $200,000?
Well, this is the standard way we do it.
Answer the question. Is it a swap or exchange of $200,000 actual cash value for $200,000 actual cash value? If the note funded the check, must they not both have equal value?
Well, I'm sorry, I'm going to have to plead the Fifth Amendment on this.
Okay. Tell me, if the bank's deposits or liabilities increase, do the bank's assets increase by an asset that has actual cash value?
Yes.
Is there any exception?
Not that I know of.
So if the bank records a new deposit and records an asset on the bank's books having actual cash value, would the actual cash value always come from a customer of the bank or an investor or a lender to the bank?
Yes.
All right. Is it the bank policy to record the promissory note as a bank asset offset by a new liability?
Yes, it is.
Does the promissory note have actual cash value equal to the amount of the bank loan check?
Yes.
Then, does this bookkeeping entry prove that the borrower provided actual cash value to fund the bank loan check?
Well, yes, it does. The bank president told us to do it this way.
All right. How much actual cash value did the bank loan to obtain the promissory note?
Nothing.
Then how much actual cash value did the bank receive from the borrower?
$200,000.
So then, is it true you received $200,000 actual cash value from the borrower, plus monthly payments, and then you foreclosed and never invested 1 cent of legal tender or other depositor's money to obtain the promissory note in the first place? Is it true that the borrower financed the whole transaction?
Yes.
Are you telling me the borrower agreed to give the bank $200,000 actual cash value for free, and that the banker returned the actual cash value back to the same person as a bank loan?
I was not there when the borrower agreed to the loan.
Do the standard Fed publications show the bank receives actual cash value from the borrower for free, and that the bank returns it back to the borrower as a bank loan?
Yes.
Okay. Do you believe the bank does this without the borrower's knowledge or written permission and authorization?
No.
To the best of your knowledge, is there written permission or authorization for the bank to transfer $200,000 of actual cash value from the borrower to the bank, and for the bank to keep it for free?
No.
Does this allow the bank to use this $200,000 actual cash value to fund the $200,000 bank loan check back to the same borrower, forcing the borrower to pay the bank $200,000 plus interest?
Yes.
Then if the bank transferred $200,000 actual cash value from the borrower to the bank, in this part of the transaction, did the bank loan anything of value to the borrower?
No.
Is it the bank policy to first transfer the actual cash value from the alleged borrower to the lender for the amount of the alleged loan?
Yes, it is.
Does the bank pay IRS tax on the actual cash value transferred from the alleged borrower to the bank as income?
No, because the actual cash value transferred shows up like a loan from the borrower to the bank, or a deposit, which is the same thing, so it's not taxable.
If a loan is forgiven, is it taxable?
Yes, it is.
Is it the bank policy to not return the actual cash value that they received from the alleged borrower unless it is returned as a loan from the bank to the alleged borrower?
Yes.
You never pay taxes on the actual cash value you received from the alleged borrower and keep it as bank's property?
No. No taxes paid.
When the lender receives the actual cash value from the alleged borrower, does the bank claim that it then owns it and that it is the property of the lender without the bank loaning or risking 1 cent of legal tender or other depositor's money?
Yes.
Are you telling me the bank policy is that the bank owns the promissory note, which is the actual cash value, without loaning 1 cent of other depositors' money or legal tender, that the alleged borrower is the one who provided the funds deposited to fund the bank loan check, and that the bank gets funds from the alleged borrower for free? Is the money then returned back to the same person as a loan, which the alleged borrower repays when the bank never came up with any of its own money to obtain the promissory note? Am I hearing this right? I give you the equivalent of $200,000. You return the funds back to me, and I have to repay you $200,000 plus interest. Do you think I'm stupid?
All the banks are doing this. Congress allows this.
Does Congress allow the banks to breach written agreements, use false and misleading advertising, act without written permission, authorization, and without the alleged borrower's knowledge to transfer actual cash value from the alleged borrower to the bank and then return it back as a loan?
But the borrower got a check and the house.
Is it true the actual cash value that was used to fund the bank loan check came directly from the borrower and that the bank received the funds from the alleged borrower for free?
This is true.
Is it the bank's policy to transfer actual cash value from the alleged borrower to the bank and then keep the funds as the bank's property, which they then loan out as bank loans as if they actually owned it and loaned their own money?
Yes.
Was it the bank's intent to receive actual cash value from the borrower and return the value of the funds back to the borrower as a loan?
Yes.
Do you believe that it was the borrower's intent to fund his own bank loan check?
I was not there at the time, and I cannot know what went through the borrower's mind.
So if a lender loaned a borrower $10,000 and the borrower refused to repay the money, do you believe the lender is damaged?
If a loan is not repaid, the lender is damaged.
So is it the bank policy to take actual cash value from the borrower, use it to fund the bank loan check, and never return the actual cash value to the borrower?
The bank returns the funds.
Was the actual cash value the bank received from the alleged borrower returned as a return of the money the bank took, or was it returned as a bank loan to the borrower?
As a loan.
So how did the bank get the borrower's money for free?
That's how it works.
No more questions, Your Honor.
If you have your original closing mortgage documents available, you will be able to flip through them and see what the mortgage company has done to defraud you. The two main documents that I will be referencing will be the note and the deed of trust, aka mortgage. The note is commonly referred to as a promissory note. However, it is not a traditional promissory note. At the end of this mortgage fraud settlement process, which takes 2 to 4 months to complete, you will have battled the bank's trustees to obtain your property free and clear. After all, you are the rightful owner of your home. Look at your deed of trust. Your name is on it. You've already paid for your house. It was paid in full before you even signed the paperwork at escrow, and you didn't even know it, nor was it disclosed to you. Let's talk about the promissory note. The promissory note starts out referring to you as the borrower. It talks about the borrower's promise to pay. Following those words, it says, "In return for a loan that I have received." After that, it says, "I promise to pay," and then the exact dollar figure amount is listed. Then the promise note mentions the installment payments and interest. Then the note says, "In return for a loan that I've received." Then a date is listed on that note. Now the question is, when you went to the title company or escrow office and signed all those documents for this mortgage, had you already received the loan? That's a very important question. The note that you signed says at the very top, "In return for a loan that I have received." What this is telling you is that you received the loan sometime before the date that you signed that note. Okay, let's say you signed the note on February 12th, 2005. "In return for a loan that I have received" really means that at some point in time before February 12th, 2005, I received the loan. The fact is, you did not actually receive the loan before that date. Matter of fact, you never received any kind of loan at all, at any time. This whole loaning you money to buy a house is a complete total fraud. The court knows it, the bank knows it, they all know it. The only one that don't know it is you. The fact is, you did not receive a loan before the date that you signed the note. You didn't see a cashier's check in the mail a few days before you went and signed the papers, did you? You didn't get any kind of electronic transfer into your checking account before you even signed the paperwork either, did you? When you go to the title company and sign the mortgage documents, you see the words at the top of the note, "In return for a loan that I have received." You might think, I'll sign this, and after I sign it, I guess I have received a loan. But that's not what the document is saying. If there is ever a legal controversy concerning whether or not you actually received the loan prior to signing or assume you received the loan at the time of the signing, which side will win? The side that argues their assumptions, or the side that argues the exact words on the page you sign? You know the answer to that, or at least you should. It's the words on the documents that will win. When you see a document that states, "In return for a loan that I have received," and you know for a fact that you have not received the loan, something must be odd. When it says, "have received," in past tense, as though a past event has already occurred by the date you're signing the note, you know that it has a meaning. Everything in legal terms and legalese means something. Let me repeat that. Everything in legal terms and legalese means something. It's up to you to find out. If you know that something is wrong and someone's not telling the truth, then who is it? That means someone is not disclosing something to you. As you take a closer look at the note, something very interesting has taken place. Did you know that you created the note? Did you also know that you created the deed of trust? If you closely examine the wording on the note and the deed of trust, it will begin to make sense to you. It says, "I will do this, I will do that. In return for a loan that I have received, I promise to pay. I understand this, I understand that. I will do this," etc., as it proceeds through the note. You realize that these are statements that they have printed out for you, but you are the one who is signing the documents. So it appears as though you have produced and provided these documents to them. In signing these documents, you assert that, "In return for a loan that I have received." It looks as though they are tricking you into signing a statement that isn't true, you might think. At some point in time in your latter years, you may have an epiphany and think, "Hey, they made me sign a statement that wasn't true. It was a lie." By doing this, the bank is putting that lie that you've received a loan into your mouth. You are the one that's signing it and saying it, and that gives the bank the privilege to say, "The borrower says and agrees that they've received the loan, so we'll proceed on the basis of what they said and signed to." The bank will then go ahead and proceed as though you received it, and then they will require you to make payments, plus interest. This is not a fair transaction when no loan was provided to you in the transaction. This is called an unconscionable or unilateral contract. No money was actually provided to you as a loan. In return for not providing a loan to you, you have to pay the bank a payment every month for the next 30 years, aka 360 months. The next question that comes to mind is, if no loan was provided, where did the money come from to pay the seller of the house? The person I bought the house from got paid, so where did the money come from? This is where the entire loan process gets very interesting. I'll compare what happens in a normal real estate transaction with this analogy. Okay, let's say that I advertise my car for sale. I'm driving my 1999 Honda Civic, even though it has 120,000 miles on it. You know about Hondas, they run for a very long time. So, I put it on Craigslist for $2,400, hoping that I can sell it for at least $2,000. You now see it advertised. You come over and take a good look at it. You offer me $2,000. So I say, that sounds great. We have a deal. You tell me that you would like to pay by check. Is that a deal? I say, sure, I understand. People don't walk around with $2,000 in cash all the time. So you write me a check. However, I won't let the car go until the check clears. You say, that's fine. We then agree. We have a deal. We agree. We have a deal. You write me a check. I give you a receipt, and that protects your side of the deal. I take that check. I deposit it into my account. I draw some funds off of it. The rest of it, I'll leave in the account. Within a couple of days, you check your bank account online. You see that there's $2,000 less in your account. Furthermore, I can see that there's $2,000 more in my account. Your check is cleared. This means now that you are ready to approach me for the car. We both acknowledge that the check is cleared. You then state to me that it's time for you to take possession of the car and the title. But I say to you, all right, I'll give you the keys to the car, but I've decided to change the deal. I'm not going to transfer the title over to you. You can take possession, but I won't give you the title to the car until you pay me $45 a month for the next 20 years. How you like that? You're now thinking, that's crazy. That's ludicrous. That would never happen to anyone. No one would ever agree to that. Yet every day of the week, in thousands of mortgage transactions all over the country, this type of scenario is taking place, where bankers and escrow officers are writing these loans, making borrowers enter into these unfair arrangements, with one exception to the car buying scenario, and that is disclosure. I disclosed to you when you came to take full possession of the car that we both understood that the payment in full had been made. That's really the only difference between this car sales scenario and when people get into these mortgage loan arrangements. You see, the lender is not disclosing that there actually isn't any lending going on. They're not telling you that the note you signed is not a promissory note. It is actually a cashier's check or bank note when you look at how it's actually structured. Take note. When you sign your name to the note and hand it over to the lender, this is what happens to the note. The lender takes that note as though it were a cashier's check or a personal check and deposit that document into their bank account as if paid in full. On the back of the original note you signed, the banker stamped, paid to the order of, and deposited that note as cash into the bank's account. The banks accept these promissory note documents as negotiable instruments and treat them like a cashier's check or cash deposits. That promissory note becomes a cash deposit to the bankers, who just deposit it into their account. It becomes cash to the bankers, and you just paid off your house with cash as far as the bank is concerned by signing that promissory note at escrow. The next question is how the banks treat your note on their records. In this fractional banking system, for every dollar that is on deposit in any particular bank branch, that bank has the ability to issue $10 of credit. Your cash deposit, i.e., the promissory note you signed at escrow, creates an asset they can use. Think of a $250,000 note that is put on deposit. That means $2.5 million to the bank. It's a great deal for the bank, but it's not a great deal for you. You see, the bank did not disclose to you that when you came to the escrow table to sign all that paperwork, that payment in full was already made by you. You were tricked into issuing to them that what you thought was merely a promise to pay, but they took your promissory note as a payment in full. You paid it in full. Now, what arrangements did you agree to under the deed of trust when payment in full was made? The bank is supposed to then initiate the reconveyance process. This is the process whereby the mortgage lien is removed from your title, but they don't. They don't tell you that payment in full has been made. That's another part of the fraud. They're asking you to pay for that whole mortgage one more time. I won't go into depth here about how the banks sell your note and get paid all over again, or the process called securitization. You can read the FBI documents in the website resources about securitization, which is another way the entire mortgage obligation gets paid again. When the mortgage note is converted from a plain document that is signed at the beginning of the loan, you think you're receiving a negotiable instrument, but instead, the note is deposited as cash into the lender's bank account. This means that your promise to pay has been fulfilled, paid in full. Under the current Federal Reserve System, there is no actual money to pay for anything. So the Feds has authorized that the bonded promissory notes, money orders, signed by you, the borrower, can be converted into cash and paid to the bank. They actually get that fiat money from the promissory note, money order, from the United States Treasury. But that's another story. The contents that has been expressed herein has been for educational purposes only. If you like this content even more, let us know, and we'll come back with more in Part 3. Welcome back to Part 3 of Mortgage Fraud Exposed. The proof of what I've been saying is in the language of your deed of trust. It's in black and white. This language is towards the end of the second page. If you're in a state that doesn't have a deed of trust, the document is referred to as a mortgage. The language I am referencing starts with borrower's conveyance. Those words should be in capital letters. What that says is that the borrower, meaning you, covenants, gives a solemn promise, and can confirm the following fact. The borrower covenants that they are lawfully seized of the estate. What does that mean, legally seized? It means in possession of. You are in full possession of the estate. In other words, you possess the property free and clear of all encumbrances. It further explains that the borrower has full legal rights to convey and or grant the property to someone else. That means that you can now sign the property over to someone else if you want. The question is, can you legally give something away that you don't legally own, even if someone else owns maybe 5% of this thing? Do you have a legal right to give it away? No, of course you don't. From this point on, listen very closely and pay attention. You see, you have to be legally seized of that piece of property in order to give it away. It is right there in your deed of trust. It says that you are legally in possession and legally own this property. Then at that point, you are choosing to convey it back to the bank just because the paperwork said you had to. One may ask, how are you able to do that if you don't already own it? The very simple answer to that question is, you do own the property. And since you are legally seized of the property, you simply signed it back over to the bank. Okay, how is it that I own the property? You own it because just 5 minutes before, you signed a document called a note. The note was accepted as payment in full, but they never disclosed that to you. The following papers prove it. In this signing process, the note is signed first, and then right after that, the deed of trust is signed. That very precise order of things is very important, and it's always the case. You first pay for the property with the note. At that moment, you own the property free and clear. You have now become the owner by your payment in full. You are now the authorized owner. You now have the ability to turn right around and give the property away, which you go ahead and do, unbeknownst to you. I bet you had no idea that this is what happens at closing. No one ever disclosed to you that you fully own the property free and clear. This is basically how they defrauded you. This is how they're able to steal your property right out from under your nose. They had you sign documents that you had no idea that it was being treated as cash. You also didn't know that the note you signed is accepted as payment in full to pay off the property. Further, it was never disclosed to you that you now own the property free and clear at the moment you signed the paperwork. And they never disclosed to you that you simply signed the property back over to the bank when you signed the deed of trust. The banks, the attorneys, the escrow officers, they all fooled you into owning the property by signing the note, and then they also fooled you into giving it away by signing the trust. Within a 5-minute period of time, you come into full possession of a property and then give it away, not knowing that the whole entire thing took place. The problem is that none of this was ever disclosed to you at the time during the loan process. You assumed that you were receiving a loan from the bank, but in actuality, you signed the note. Your signature on the note created the money to fund the loan. If you look at your deed of trust, it will call you the borrower, and the bank is called the lender, but no money was ever borrowed or loaned. Again, you would ask, how did they get away with that? Well, it's simple. The meaning of the words were changed to suit their fraud. Legalese. The whole entire process is deceptive, and it has not been disclosed to you in order to accommodate their fraud. For instance, your note. After it has been deposited at the bank, it is sold to other investors, but that process was never disclosed to you. Your next question is, what are we claiming? Are we going to bring forward a breach of contract? No, not really, but that is one of the things that you are certainly bringing to the light. It is very important to let the other side know that you know, but they count on you not knowing these things. The banks and their attorneys assume that you are ignorant, which is what gets the whole entire thing rolling in the first place. It's your ignorance of the true nature of the transaction. If they sense that you don't really know what you're doing, of course they're going to proceed with a foreclosure and or collection, or assume that their contract is in effect. When you begin to do this process, you will discover that the banks and their attorneys will ignore you and your paperwork. They will assume that their contract over you is superior and will ignore all your paperwork. They will begin sending you authoritative letters of their own denying your claims. The attorneys for the banks live to bluff and bluster, but the truth is, you're the one that's in control. You give them enough information that indicates that you know you have the right, because you are the truster, maker, creator of the trust. You're the one who created that document, and you're the one who made the initial assignment and appointments that got this whole entire system going in the first place. Thanks to this process, you established through the bank's own permission, due to their non-response to our notices, that you still have that power. You now have a new contract which indicates their understanding that you have the power to appoint someone else as trustee. You have the power to now revoke their appointment as trustee and beneficiary. That's where your deed of trust for correction of fraud comes into play. You file that at the county recorder's office. This is, in general terms, the process that we follow. We revoke their appointments that have been made that set up their authority to do a foreclosure or make a payoff claim in the first place. If you have revoked the bank's trustee and stripped them of their fraudulent authority, they have no documentation to rely upon if this actually ends up in front of a judge. In fact, our documentation will give you that power, which they will not want to challenge once established. They don't want that situation, and they don't want it to end up in a lawsuit against them, but that's what we do, because we encourage to bring the facts forward. What you're doing by preparing yourself is having a file full of documents you've done in order to present your claim to a judge. You do this process with an eye down the road, if and when you sue the bank, and you will have to sue the bank. All the documents are geared with the lawsuit against the bank in mind. 42 U.S.C. 1983. The question arises, how do you prove that you paid? Do you subpoena them for their records? We suggest that each client in our system submit an affidavit of facts asserting that the payment was made in full. That then makes them have to prove that it wasn't true. The only way to rebut an affidavit is to provide your own affidavit, point by point. Those are the rules. If they haven't provided an affidavit to overcome the one that you provided, then under law, they are essentially agreeing with what you said. Silence is acquiescence is the legal rule on that. There also comes a point in our process where if you've done all the right things, they have to then listen. Essentially, they have to listen. You're then now in the driver's seat. The bank knows that proceeding forward and just ignoring you could actually mean criminal charges to the human beings that are taking these steps. There are consequences to engaging in fraud, only if the victim knows what's happening to them. On top of that, we even offer to pay them funds by creating a promissory note or money order and sending it to them. If they don't credit the payment offer and deny payment, that is also an indication of fraud and denial of payment. Before we take the steps of a 42 U.S.C. 1983, we give them so many ways to comply that overwhelms any legal argument in our favor. You then ask, how is the U.S. Treasury involved in this? The funds that are drawn from our signature actually comes from a shadow account that's kept in our all caps name with the U.S. Treasury Department. We as individuals are the originators of all credit in this country. When we as authorized agent for those accounts sign our name, what we're doing is authorizing the account with the U.S. Treasury to be taxed. That then makes us the originators of these funds, just as if we printed real money. It's accounted for that way in our all-electronic banking system. That makes us the originators of the loan, whether it's a credit card, an auto loan, or any of these things. If we are the originator, then the other side of the transaction, the other party, is not providing anything. That alone makes it an unconscionable contract, aka unilateral. In other words, there was no consideration. They bring nothing to the table. That then means that they came to the table with unlawful intentions and unclean hands. Think about it. If you provided the funds and they don't, then what are they providing? Nothing. Forget the fact that the note you just signed doesn't have another signature other than yours. Forget also the fact that the deed of trust doesn't have another signature other than yours. The fact that you are the originator of the funds means you don't owe anyone anything. You already paid for it. Now you ask, how does my signature work? If you look carefully at your deed of trust, aka mortgage, you'll find that there is no other signature, only yours. Look at the end of the note, and you'll find that there is no other signature, only yours. Okay, listen to this. When you write a check, when you buy your groceries, or you pay your electric bill, do you have some representative at the grocery store also sign the check? Of course you don't. Do you have an associate at the electric company also sign the check? Of course you don't. It's the same with the note. You're basically signing a check. Because you're signing a check, a negotiable instrument, there doesn't need to be another party signing it. You sign it, then you say, here's your payment. You offer, they accept it, and deposit it. It's money to them. It's money to them, and it gets balanced out through the electronic shifting of numbers later, all stemming from your treasury ledger. This is the main reason why you have every right to a free and clear title of your property. You paid it entirely. The entire obligation is satisfied. You see, we keep coming back to the fact that the only way that this lender could be given the property is whoever gave it to them had the right to give it to them. And the only way you have the right to give it to them is if you own it free and clear. Makes a little sense now? There must have been some mechanism by which you became that free and clear owner. The only mechanism that there could possibly be is if you paid for it entirely. And if the payment was accepted as payment in full, it was. One thing that we have to remember, and you must wrap your brain around, is that you are actually the lender in these cases. Qualify everything and study. They're not just going to hand it to you. You are in a fight. You pose another question. How am I the creator of all credit and notes, and why is this so important? You see, you are the creator of the trust. That's what the paperwork says. You are the trustor, grantor. Those two words are synonymous. They mean the same thing. In some states, it's grantor, and in other states, it's trustor, but it means the same thing. You are the one who created that trust. You created that document. They simply printed it out. Before I close, let me give you the basic mortgage fraud process. At some point, you will use these as exhibits in your 1983. Number 1, request for information, a qualified written request, RESPA, and turn their demand payment, 30-day payoff statement, which is a mortgage statement, into number 2, a money order, bond promissory note, as tender of payment for payoff, utilizing your trust account at the U.S. Treasury. Number 3, use your right to cancel the alleged contract. Number 4, revoke the power of attorney. Once that's been done, then, number 5, file your notice with the county to make it public record, recorded, that you have taken your voice back, and now you hold power of attorney. Then, number 6, revoke the trustee. Then number 7, revoke the beneficiary. Number 8, revoke the lender and their liens using a quick claim deed. You revoke all those relationships because you have the right to do so, thanks to the agreement forms when the bank failed to respond to your offers. But the final process starts with the power of attorney. Then if you desire, you can follow up with the optional of enforcing the process, filing a lawsuit, filing a criminal complaint with the FBI, filing a fraud complaint with the IRS, filing a commercial lien against the bank, etc., which is optional and only done if necessary. But you now have a strong case if they decide to fight you or you elect to sue them. Your evidence now is much stronger than theirs. Let's now talk about some of the basic rules of contract or contract law. If you understand these rules, the documents will make more sense to you. It is very important that you go through this prior to reading our documents. As you read through the documents, the complaint, the lawsuit, you will see that it's full of legal terminology and specific wording. For there to be a contract, there has to be a meeting of the minds. This simply means that two parties understands what the agreement was, whether it's a handshake or a posted sign like a speed sign on the road. We all enter into contracts dozens of times throughout the day, whether it's tacit or oral agreement. During our whole lives as debtors in this society, we are all set up so that we are constantly being entered into contracts. You see, everywhere we go, we're paying fees, registering, licensing, and even agreeing to do something. When you simply agree to walk through a store without shoplifting, that equates to a contract. Look at it as if laws are really contracts in commerce. If only you can keep in mind that everything you do is a contract, many things in life will begin to make more sense to you. Even when the government passes codes, rules, regulations, and laws, they're all contracts. If you don't object, you become subject to those laws. Then you ask, how do they get away with it? First, we voted the representatives in. Second, they assume we won't argue or stand up against it, even if what they do is unconstitutional. I believe that Congress passes many unconstitutional laws, but if we don't stand up as we the people, they get away with it. Silence is acquiescence. Everything we do in life is a contract. Even the Bible is a contract. It's a book of laws. Even when going into court, it is actually about contracts. Once you answer that judge with whom you are and plead guilty or not, you've entered into a contract and you're now subject to that court. That court now has personal jurisdiction. Another concept to understand is silence. If you clearly let someone know and give them ample warning on the issue, or you notify them of certain things and they don't dispute those claims, then their silence is in agreement with those claims. You need to clearly prove that they were notified properly and understood the nature of those statements. Our mortgage and debt documents do that process as well. The silence is acquiescence, and the concept is definitely a part of what we do. We are carefully following a not lawful process, all legal, not reinventing anything new. But how we apply it, however, is unique. For example, you send a letter out to the bank, and the bank appears to respond to that letter. But if you actually take a closer examination of the original letter that you sent, it outlines what the correct and complete response is, and that anything less is no response at all. A partial response is not a response. It is still silence. Unless it's a specific, exact response, it's not a response. It's a diversion. It's a curveball response. The opposing side wants to see if you will quit at that point. So persistence and demanding exact, complete responses are very essential to your success. Persistence will get you through this. No matter what happens, go to the next step. That's critically important. This is where you succeed or fail with this process. Most clients get too caught up in it, and they don't realize that they have to go all the way in, from point A to point Z, not point A to point G. That's really what it takes in a nutshell. Another concept we need to understand is that fraud vitiates contracts. That means that if the bank's representative or escrow officer did not disclose something to you in the original agreement, or, in the case of mortgages, they misused or monetized your note in a certain way, were paid off, and didn't tell you, it's potentially considered fraud. If that happens, if you read the language in the documents, it vitiates or eliminates the original mortgage contract, the mortgage debt. What I'm trying to say is that's one more piece of your ammunition to get fair treatment. Remember, all these things become your ammunition, which you have the right to utilize. Fraud vitiates contracts. If the bank committed a fraud against you and they don't deny it, their silence is admission of the fraud. Then, when they don't produce an original contract, we are granted certain permission, as written in our agreement when you send it to the bank. That is why you go in and change the power of attorney and the trustee and the beneficiary and remove the lien. Is it easy? Not by chance. If you're not ready to fight, don't do it. If the bank's attorneys don't try to stop this process, even after, when we've outlined how they've committed a fraud, their silence is agreement. Trust me, they really don't want to go to court with your pile of evidence stacked against them. That's why you be persistent and push the process forward. You see, the more steps you take, the more ammunition you have, just in case they ever try to get you into court, or you decide to take them to court. Before closing, let's talk about claims. A claim is when someone says, "We have an agreement, and I have genuine proof of a contract." The nature and the form of the mortgage agreement is that the note was signed as escrow, with the assumption that the bank gave you real money. But did the bank give you real money or substance? Okay, bank, why don't you show me proof of that? And while you're at it, show me the original note that I signed. You see, if they don't show up with the original note, they can't prove their claim. Even attorneys will tell you that. If the banks cannot prove their claim, they don't have a case. Lawyers can argue all they want, but the fact is, without proof of claim, there's no claim, there's no contract. You see, there's no real contract for you to pay back a loan that your signature created out of thin air.
So, as you can see, these banks have been frauding the American people from the beginning. This happens in Britain also. There is a documentary that's out. I think it's called The Great Mortgage Scam or something like that. That actually was in Britain. But you know, this practice is something that's hidden in their processes and their documents, and you know, we as lay people don't understand these things, and we're just ignorant to them, and we don't take the time and the steps to be able to learn and read these documents and understand them. And you know, that's our fault, right? But now we know, so now it's our responsibility to do something about it. So I challenge you to, further research this. You can go to a website called Scribd, SCRIBD. It's a great resource for, any book, document, anything. Like my digital library is ridiculous because of this website, and there's so much information on this website. So you can go there and search and try to find more information on that if you like. Again, you can find the documentary, The Great Mortgage Scam. I believe I found it on Telegram. Just search it, and I'm sure you'll find somebody's page that has it. But I hope you're starting to see a theme here, right? Like we started out with the moon landing. Okay, now it's mortgage fraud, and these are things. These aren't like little things. Okay, these are things that affect every person. Okay, the moon landing itself, how much is based off of what we know and understand, what we teach our children is based off of the fact that we went to the moon in 1969, and everybody lives in a house. Everybody lives in a house, right? For the most part, right? So if you are buying a house, anybody that's buying a house, which is a lot of people, over decades, okay, they've all been defrauded just like this. So my job is to share with you the truth. That's my job. And, a lot of the time, truth hurts, but, it's better to know, understand, to be able to navigate through it and be able to make it right rather than to not know and live in ignorance. So until next time, I'm sure I'll have something else that'll make you mad. Peace.